This is a training that's mandated by the EEOC, Equal Employment Opportunity Commission. But I'm John, as Janet said. Andre is a partner with Beauty and Curliano, firm that works with Janet quite a bit, works with me a lot. And we're here to talk about EEOC trainings and discrimination.
And hi everyone, my name is Andre Licar. I'm with the firm of Beauty and Curliano. We have an office in Oakland. I think we've done a little bit of work with your company, but we do a good mix of stuff in Oakland, a lot of employment litigation, mostly for the defense side, sometimes for the plaintiff side, but that's usually after a complaint's been filed and there's a court involved and other attorneys, so all kinds of stuff that we're hoping to avoid with today's presentation. And I'll let John go forward.
Yeah, so why are we here and goals of the training? As I said, there's been some previous issues. So part of this training is how do we make sure that this doesn't happen again? So the main takeaway, what we want to kind of make sure that people get is, where's the breakdown here? Where is it that when somebody should be talking to HR or maybe pushing it and engaging counsel or something like that? What's happening to where there's a risk to the company, a risk to Mountain Cascade of a discrimination claim, a lawsuit, something like that. So major goal here is just to get on your guys' radar if when it's a good idea to, hey, let me talk to somebody about this. Let me escalate this. Maybe we need to bring a lawyer in because this seems like it could be risky. Second reason why we're here is this has been mandated by the EEOC that we have this training. There's certain topics that we have to cover in this training. So if some of it gets a little dry, this is what compliance requires of us. Obviously, ensuring this doesn't happen again. And then another goal is just to talk about California in general, because California is the most employee-friendly state. It's a state full of litigious plaintiffs and litigious attorneys. And being in California, you're already at a greater level of risk, essentially.
And yeah, I would agree with John. I don't know if I would call it a danger zone for employers, but I definitely agree that there's a lot of laws out there in California that are very employee friendly, which can be a good thing, but it's not intuitive stuff. It's stuff that a lot of people aren't aware of. There's I deal with this stuff every day, and there's new rules or regulations that I come across that I wasn't familiar with, and it's stuff that's not very intuitive for employers. So I think a good part of today, if you can just take away from today, is kind of just a general idea of some of the areas that you should be aware of or just concerned about. I think would be a very beneficial use of today's presentation.
Little background on the EEOC. It's a federal commission, right? Appointed by the president, 5-year terms, staff of thousands to help administer, and EEOC can file discrimination charges and go to court on behalf of aggrieved individuals. That is how the EEOC got involved with Mountain Cascade. There was an aggrieved individual, filed a complaint. Process ensued, which kind of looks like this. Complaint is filed, EEOC reviews it, they notify the company, in this case would be Mountain Cascade, say, hey, are you going to settle this? If that doesn't happen, they initiate an investigation. Okay, and that's what happened in this case. They're seeing what happened, right? What went on, talk to the company. This is where we'll get into documentation. It becomes extremely important because it's he said, she said, what can we prove, right? So they investigate, they issue a determination, and then they either decide, yes, discrimination took place, or no, discrimination did not take place. And in the case that sort of precipitated all of us being here, they determined that discrimination did take place. So that's the EEOC, that's the complaint process. It's really, you don't really need to know the intricacies of the EEOC. What you need to know is what to do and what not to do.
And I mean, I would just follow up that you have the EEOC in California. You also have lots of other different sources for people to make complaints. You have the Labor Commissioner, which deals more with wage claims and things of that nature. But you also have just people can file their own lawsuit. People can file their own complaint pretty easily after they get a right to sue letter from the EEOC or from the California Labor Commissioner. And in California, the attorney's fees are, the way they're set up is a lot of times they're available for plaintiffs, not so much for the defendant. So there's a lot of motivation for attorneys to really litigate these claims and to take a lot of plaintiff side claims and file those lawsuits against employers, because even if they recover a small amount, they can come back and ask for 10 times that in attorney's fees. And if the employer loses in court, they would have to pay that. And if they win, rarely do they get an award of attorney's fees themselves. So it's very friendly for plaintiffs' attorneys to really try to bring these claims and to sue employers. So all these reasons are just, more and more reasons why this area of the law is something that you should all be aware of.
So, bodies of law that come into play here. There's federal law and there's California law. As you can see, there's a whole bunch of federal law. There's also a whole bunch of California law. It doesn't necessarily look like it here, but there's been so much legislation put in place, litigation that's happened, that's created this real a real range of ways that an aggrieved employee can come back to the company and say, I was discriminated against. Equal Pay Act of 1963, and most of these laws are obviously put in place for the right reasons, right? Equal Pay Act to ensure that men and women receive equal pay. Civil Rights Act, Title VII is the big one that's discrimination law and anti-harassment law comes from. Civil Rights Act of 91, Pregnancy Act, ADEA, which is Age Discrimination in Employment. We're going to talk about that. And then the ADA, which is Americans with Disabilities Act. So there's a ton of legislation here that kind of comes together to create this body of law. And then California law as well.
Yeah, and the specifics of all these laws, I think, is definitely beyond today's presentation. But there are general principles that are in the federal laws as well as in the California laws concerning discrimination. And I guess those principles are what we're hoping to cover today.
All right, so what is discrimination, right? This is a discrimination training. Let's start with, what is it, right? It's when an employer takes an adverse action against an employee motivated by discriminatory intent. Basically, when you fail to hire, fail to promote, when you fire someone for a reason that doesn't have anything to do with their capabilities on the job, right? Termination, demotion, reduction in pay, failure to hire, denying a promotion for a discriminatory reason. We'll get into the various different reasons, but basically it's when the company, meaning you as agents of the company, as managers, you're essentially an extension of Mountain Cascade. When you don't promote a guy, let's say hypothetically you didn't promote somebody because of their race, well, that's obviously discriminatory. That's pretty self-explanatory, but where we get into trouble and what we're going to spend most of the time talking about is the much more nuanced aspects to this, how there can be competing sets of facts, how you may have been firing them for a legitimate reason, but they're claiming that it's a discriminatory reason. Many different scenarios kind of under that umbrella. But essentially, discrimination is when the company takes action against an employee for a reason that has nothing to do with the job itself.
Yeah, and I'll just, I guess it's a little hard to comprehend, but it is America, and you can fire or take adverse action against someone that, if you don't like them, you can fire someone if you don't like them. If someone is a 49er fan and you don't like 49ers, you can terminate that person for being a 49er fan. There's only two real times when you can't do that, and so that member is a part of a protected class, or if they're engaging in protected activity. And fortunately or unfortunately, depending on how you look at it, I think fortunately in a lot of cases, those protected classes are very broad, and we'll get into what those protected classes are, and that protected activity can be also pretty broad. I would guess that most people in this room would be somehow a member of some protected class under California law. So, you really do get into kind of a he said, she said, or he said scenario where if your reason for terminating someone is because they were performing badly or you didn't like them for a legitimate reason, but you can bet that a lot of times they might come back and say, well, I was really terminated because I was part of this protected class and that protected class, and that's where a lot of these lawsuits come from.
So what are the characteristics that places one in a protected class? Some of the obvious ones: race, color, sex, age. Anybody know what age is the protected age? Over 40? Good job, that's it. We've been to some of these trainings already, so glad you guys have the answers. Religious belief, grooming practices, national origin, marital status, physical or mental disability. We're going to spend a lot of time talking about this one today, especially in a physical type work environment like Mountain Cascade often is, where a disability can have a tremendous impact on someone's ability to perform the essential functions of the job. So what is the analysis that takes place when somebody has a disability? How do we weigh the company's responsibilities, the company's obligations versus, whether or not this person really can or can't do the job? So we'll talk about that a lot. Veteran status, sexual orientation, sexual identity. The second 2 hours of this training, when we talk about anti-harassment, we'll go a little bit more into the protected classes. So you'll just have to wait around for 2 more hours to get the full list. Keep everybody in suspense. Anything you'd like to add to?
Sure. And yes, there is an exhaustive list of these, but I think this does cover the major ones. 2 other points I'd make is that if you perceive that someone is a member of this class, that can itself give rise to a claim of discrimination, even if someone is not of a certain race or of a certain age. If you perceive them and there's somehow evidence that you thought that they were a member of this class, that can give rise to a claim of discrimination. Also, there's a whole other line of causes of action that we see for associational claims where the employee is claiming that you discriminated against me not because I'm a member of a protected class, but because either my wife or my husband is a member of a protected class. Maybe they're disabled and you're discriminating against me because I have to take time off to go home or care for that person. So just be aware that it can also be associational, that the employee associates with someone of this protected class.
And you can imagine, maybe 1950 or something, somebody's married to somebody of a different race, they get denied a job because of their spouse. That would be sort of a obvious example, right? So 2 types of discrimination. Basically, this is the way that the law looks at this. Disparate treatment. This one's a lot easier to spot than the second one. This is sort of the most obvious one, which is the employer singles out an employee because of a protected characteristic, right? I'm not promoting you because you're older. Now, obviously, or hopefully, obviously, you as a manager wouldn't say something like that, something that blatant, but that is what disparate treatment discrimination essentially is. The plaintiff in this case is going to say, the reason I got fired or the reason I wasn't promoted is because of my race, because of my sex, directly because of my sex. Disparate impact. This is a much more much more difficult kind of discrimination to sort of to see. It's less obvious. It's basically when you have a policy that on its face is fair to everybody, say an attendance policy where anybody with perfect attendance gets a bonus, right? Applies to everybody equally. On its face, it's a totally fair policy. But on deeper inspection, it's obvious that pregnant women are discriminated against due to this policy, because if you're pregnant, you can't have perfect attendance, okay? So that would be a policy that has a disparate impact and is in fact discriminatory, despite the fact that it seems like it would be a fair policy.
And I would just add, yes, that it's definitely harder to kind of quote unquote catch the disparate impact issues. But when you're, if you're in charge of putting out a policy or creating a new policy, you definitely want to keep in the back of your mind that the policy will be neutrally applied to all different groups of people. For example, a dress code is something that comes up a lot of times. A company can have a dress code. They can have a dress code policy, but if your dress code policy is very specific towards one protected class, such as males or females, and it's a very different policy for the other type of class, that could definitely give rise to a type of disparate impact case. And also, there's things that you just need to think about. Someone could come in with a claim of religious discrimination, that their dress code policy or the company's dress code policy affects their religious beliefs. So definitely harder to catch those in the disparate treatment cases, but something to keep in the back of your mind.
Mm-hmm. I had a case. I think I may have utilized this case example at one of our past trainings, but I guess that one wasn't videotaped, so maybe it will seem like it's the first time. But one example was an Abercrombie and Fitch case, right? Abercrombie had a policy where there was no headwear. You can't wear, if you're going to be an employee that works for Abercrombie, you can't wear a hat, you can't wear anything on your head. A young woman applied. She was Muslim, I believe, and she had to wear a headscarf on her head. Abercrombie said, no, we've got a policy that nobody can wear anything on their head. If you're not going to take that off, then you're not eligible for the job. Well, as it turned out, the scarf was a religious. It was mandated by her religion, and basically the way it was looked at by the law is, it's not asking too much to let her keep the scarf on her head, right? It is not, it is not burdening the company in any major way by saying, all right, we'll make an exception for you because of a religious belief. So that would be a disparate impact type of discrimination, even though it's fair on its face. So if an employee is claiming they've been discriminated against, what do they have to prove? You want to take this one, sir?
So this kind of jumps into when the attorneys are already involved and there's a lawsuit, there's been a claim filed. There is a general three-step process that applies to a lot of different discrimination type of claims. It's what we call the McDonnell-Douglas test. The first part of the test is that the employee has to come forward and present some sort of evidence of a prima facie case of discrimination. It's a very low burden, but there are some things that they need to establish. They have to establish that, yes, they're a member of a protected class or they engaged in protected activity. A lot of times a key issue or dispute at this stage is if the employee can show that the employer was aware that they were a member of that protected class, or if they engage in the protected activity. There's several cases where, if someone is terminated, and they come back and say, well, I was terminated because I was pregnant, or I was terminated because I had complained about this type of conduct which I thought was illegal. And if the employer can come back and show, well, we never knew that you were pregnant, or we never knew about this protected activity, that's a defense to a case of discrimination. I mean, if you don't know that the person is a member of this class, that they're alleging you discriminated against them because of that, that's a pretty good defense to a claim of discrimination. But a lot of times it's pretty clear, if someone's a member of a protected class or if they tell their employer that they're pregnant or have some sort of disability, the burden then shifts to the employer to put forth a legitimate business reason for an adverse employment action. A lot of times, the work we do deals with terminations, but it could be anything relating to failure to promote someone, or even writing up someone several times. They could claim that that's because of a protected class. Legitimate business reasons for taking an adverse employment action against somebody. What are some of those? It's pretty common sense stuff. If someone is a bad employee, if they're not performing well, you can take an adverse employment action against them. You can terminate that employee if you have a valid reason for doing that. Another one that comes up a lot is reduction in force. If there's a there's a downturn in the economy and several employees have to be let go, if there's a valid reason for why you chose those employees to be let go, if they had the least amount of seniority, what we call a reduction in force, that's a valid reason to terminate a group of people. Then if you can show that you had a valid reason to take that action, the burden then shifts back to the employee to come back and say, well, their excuse for that action is a pretext, and really why they did that is because I'm a member of a protected class. And so when it gets to the stage where our firm is dealing with it, it comes down to how do you prove these things? And a lot of times the employer doesn't say, I'm doing this because you're part of a protected class. A lot of times there's not direct evidence of discrimination. It all comes down to indirect evidence. So what can that be? I mean, timing is a big one. If the employee comes to you or comes to their employer and says, I'm pregnant or I'm part of this protected class, and then the next week they're terminated, that's indirect evidence of a discriminatory reason for that termination. Timing is usually a big issue in a lot of our cases. Another source of indirect evidence is, or it can be sometimes direct evidence, is emails. And I kind of want to stress to everyone here, I'm not sure how much of emailing you do. I know I do a lot of emails, but what I tell a lot of our clients, or all of our clients, is whenever you're writing emails on a work server or work emails, just assume that those emails will at some point be put up on a projector screen and be used as exhibits in a trial. And I'm not saying, go out and discriminate and hide that discrimination by not sending emails, but I just want everyone to be aware that when you send emails, it's a very informal process. I've seen it hundreds of times where people that work together for 10, 20 years, they have a good working rapport, they have inside jokes, and they're sending emails back and forth. And even if there's really no discrimination intended, a lot of those emails can sometimes be taken out of context. And if you put them up on a projector in a courtroom, they can certainly take on a whole other light than kind of a joking email between two friends. So I would stress to everyone that just be conscious of the emails that you send at work.
Yeah, your joke definitely, the context and the humor in a joke is lost when it's being read or projected in a courtroom. Take his word for that one.
And a lot of these cases, again, just going into the indirect evidence of discrimination, it comes down to what people say. And a lot of times the employee's version of what happened, maybe even truthfully, is they see things very differently than the employer. And we go out and we interview various coworkers, and you'd be surprised at how different people view the same event, or view a working relationship, or view the reasons for someone's termination. And usually, if you go out and interview 10 different people, you'll get 10 different sides to the story. So that's why emails don't lie, and there's only so many ways that you can interpret them.
Has anybody had a situation where they want to let somebody go or write somebody up for something, but at the same time, the person has been on a workers' comp leave or has been involved in something, so it becomes a sort of muddy situation where you're really only concerned with their performance, but there's these other factors in how it would appear? Has anyone had that kind of situation as a manager? You want to let somebody go, for example, because they've been poorly performing, but they get hurt and they go out on a leave, for example. Has anyone had that kind of situation?
Like in the fall.
Like a
Like a
In
fall?
the fall, when it's going to start raining, everybody starts getting hurt.
in the fall when it starts raining. In the fall when it starts raining, everybody starts getting hurt. Right. That's the kind of thing that can get very.
Sure.
Could they not hear anything that he's said up to this point?
Really snowy conservative stop. So
I'll talk louder and you can.
I'll try to talk louder, yeah.
Okay. But, what we're talking about here and what Andre's firm deals with a lot is, all right, from the employer's perspective, there was a legitimate reason for this, right? Here's all the ways that this employee was underperforming. And then from the employee's perspective, well, I was a minority and I was the only woman on my team, for example. So then we've got sort of this situation where who's right, who's wrong, how do we make that determination?
Yeah, and that, again, I mean, some of the evidence that we look at a lot of times is documentation, formal write-ups and things like that. If someone is not performing well, it's important to document that and put that in writing. I don't know if there's a formal disciplinary, what the procedures are, but it always helps to, even if it's just emails, again, kind of reflecting the trouble this person is having with performances. That's a lot of times important evidence that we look for. And also something that sometimes we point to or a plaintiff's attorney will point to is how different employees who maybe had the same problem or same issues at work, how they were treated. And what you want to be very aware of is to make sure that you treat everyone neutrally. And if 3 or 4 different employees make the same mistake or have the same problem, one of those employees can come back and say, of these 3, I'm the only one that got written up, or of these 3 that did the same thing, I'm the only one that got terminated. That creates, indirect evidence of some pretext for that action.
How many people, as managers, write up employees every time they're performing a disciplinary action? How many people should write up people every time they perform a disciplinary? So sometimes you're writing things up. Sometimes it's busy. You're on the job site. Doesn't get handled. Do you think that would it be safer? Should you have a more sort of a more formal and formally enforced write-up process? Would that help in general? You think some yeses?
And the write-up, there doesn't have to be some sort of magic way to write person up. It doesn't have to be entirely formal. Just a memo in the file or something like that can certainly be something that you can point to in the future and say these were some of the issues that the employee was having. But again, I do want to stress that if you're doing that with one employee, you want to make sure that you're consistent with all employees, that you're treating them neutrally.
Do you find, Andre, in cases that you're litigating, the person will say there's all these issues that have been happening, but it's more difficult for them to produce some kind of evidence to substantiate that?
Yeah, I mean, I guess from both sides. A lot of times when I speak with employers, they tell me, oh yeah, this employee was terrible for 2 years. I had problems with them, and then I ask for, okay, where's that written down? How can we show that? And they have nothing to show for it. They just tell me that we had informal conversations, and I would have to sit down with them every week and kind of go over what to do. And of course, then when you go and depose the plaintiff, they have a very different recollection. So it's good to document things, I would say.
It's good to document. So one of the big takeaways is hopefully people just being able to identify, hey, this person or this situation has the potential in the future to kind of spiral or become a bigger issue, and start utilize your instinct, I guess. We've all kind of dealt with problem employees or people that have a bad attitude. utilize as much forethought as possible and say, hey, I want to make sure I document everything with this particular person. I've seen a lot of times where it is the person with the bad attitude that ends up getting hurt on the job, or at least filing a workers' comp claim or something like that. And now it gets increasingly difficult to let that person go if you were already planning to.
Yeah, we see it a lot too, where if the writing is on the wall and someone can see that they're in trouble as an employee, all of a sudden they show up with a doctor's note or something like that, where it's important to document the problems with them before they give the employer notice of some protected class.
Anybody had that situation happen?
Now you know why we don't document.
Now we know why you don't document?
The minute they feel like they're being targeted, we don't want to have workers' comp claims and these problems.
Yeah. And that's a fair point, and that's a good point. But if you have I guess the way around that is just to have a neutral policy. If you treat everyone the same way, and if there's a problem with one employee's performance, that employee gets written up, same as anyone else. That's probably the best way to take care of that.
So either you don't document anybody or you document everybody.
Yeah,
right?
well, I mean, what you don't want to do definitely is you don't want to, for some reason, be documenting only one employee unless that employee is a terrible employee and there's a lot of problems with their work.
Or if they're an under 40 white male, you're probably safe too. All right, so more on what the employee must prove. Let's see, Andre, have we covered this yet?
I think we've covered it, yeah.
Restricted company policy. Did you even come across this in practice?
It's definitely more the individual claims that we see than the company policy. But again, with the company policy, I mean, it's I guess neutrality is the key takeaway here. If you have a company policy that is applied equally to everyone, that's okay. But if it's a company policy that's applied more strictly to certain groups of people than other groups of people, that can definitely be a problem area or something that gives rise to a claim. The remarks issue, I mean, that just kind of follows up on what I said. Is a lot of times these cases are very, very fact specific. And like I said, we go in and we interview coworkers, supervisors, and they'll remember, one incident or an employee's, years long of employment very, very differently. And there's been a number of times where I'm talking to our client and they're telling us that, oh yeah, this employee was terrible and they did this and said all these terrible things. And then you ask their coworkers and they have a very different recollection, or at least that's what they're testifying to is a very different recollection than what your client is telling you.
Another note on discriminatory remarks, and we'll talk about this more in harassment too, is if one of the people that you manage, if you hear them say something, it's really important to, not let that slide, right? Because it becomes a matter of protecting the company. Maybe you hear one of the employees that you supervise, they say something, a racist joke or this or that. It's very important to everybody just to understand there's a heightened expectation of conduct at the workplace. And the fact that if there was a discriminatory remark and, the supervisor he heard it, he didn't say anything, he didn't, it could certainly, the argument could be made that you were either condoning that behavior or at least you didn't have a problem with it. So you kind of have to, I think it's difficult when you're friends with the people that you supervise and when you have a work environment that's, you don't want people not to be able to tell a joke. You don't want people not to be able to, laugh. But at the same time, you have to maintain that professional attitude. And, our job as attorneys that are talking after the fact and having seen how these things play out in so many circumstances, it's like, it may not seem like a big deal at the time, but it can go a long way just to, pull that person aside and say, look, you can't talk like that. That doesn't fly here. Months down the road, you're going to look a lot better when it's blown up on the poster board in the courtroom.
And yeah, this just follows up on what we talked about earlier, that if you have a legitimate business reason for taking some adverse employment action, that's that's okay, and that's you can terminate someone or not promote someone if they're performing poorly. If it gets to the stage where there's a lawsuit filed, they're going to come back and say that was a pretext, and that's why all this circumstantial evidence that we've been talking about is important. You're going to need to. It's a tough thing to have a defense to if someone's claiming, well, that was really a pretext. How do you show that was not a pretext? And you go back again to some of the written documents and emails sometimes, and just what different coworkers say is really what you have to fall back on in a lot of these cases.
Can anybody think of an occupation where you are allowed to discriminate based on age or a job? Where you can not hire somebody because of their age?
Models, like Hooters.
Bartending was the one I was thinking of. Models, Hooters was the other one. I don't really know the hiring requirements at Hooters, but I'll take your word for it. Point being, it's a legitimate defense if, the age is kind of an easy one, but if it's an actual requirement of the law, then you can obviously take that into account.
There's an experience requirement, they come out of college, that's another reason, right?
Yeah, that's a great example, right? If you need 5-10 years of experience and you just came out of college, well, you're 22, unless you somehow started, graduated college on like the Doogie Howser program or something, you can be turned down for that job.
But that's not a protected class, correct?
What?
40 is not protected from age discrimination.
Correct. Valid point.
That's true. Yeah.
What about when the job requires lifting and the guy can't lift?
Now we're talking. This is the good stuff. Let me see if, okay, so perfect. That's actually a perfect segue. So question was for the audience, what if the job requirement requires you to be able to lift and the person can't lift? So we're getting into disability discrimination here. Before I launch into that, any questions so far about what we've just talked about?
Does the person have to be copied that you're writing do they have to get a copy of that, or do you just do it yourself and keep it in your?
Good question.
I guess it depends on what kind of write-up you're doing. I mean, I've certainly seen situations where, two supervisors send in an email back and forth complaining about someone's performance, and that can be evidence in the future of this person was not a great performer. But I think if you do a more formal write-up and you put something in their file and you bring it to their attention, it's better for the employer to say, I warned them about this behavior. I did what I could to try to correct that behavior. It continued. Here's the continuing documentation of the problems with their behavior. So I think the short answer is no, you don't have to CC them on it. And if you don't, it still can be circumstantial evidence of this employer or this employee had problems with their work performance. But a lot of times it's better to bring it to their attention and try to correct that behavior. And then if that behavior continues, you're left with only escalating disciplinary procedures and things like that, which are then explained by the documentation.
Right. If you're saying this was the person's problem, but they were never notified that was the problem, then that's a defense on their part. Well, they never told me about it, even though they wrote me up amongst themselves.
Now, if your policy is to give verbal warnings first, are you supposed to follow up with the verbal in writing in their file only and not give them the verbal in writing? If it says it's verbal, verbal's verbal.
Yeah.
There's no way for you to document that unless you write it up.
True.
Great question. Let me repeat it for the. If the policy is to give a verbal warning first, you have to make a note that you gave a verbal warning. And does that kind of defeat the purpose of a verbal warning?
And I mean, I would say there's no hard and fast rule for that. If the policy is to give a verbal warning, and you give a verbal warning, I think you want to comply with the policy neutrally. So if your practice is to not put a note in the file that they got a verbal warning, then just make sure that's consistent with all employees. If you make a note to yourself somewhere that you gave this person a verbal warning, or even if you put something in their file that reflects a verbal warning, I would just stress that you want to do that consistently with all employees.
I like, in an ideal world, if you gave someone a verbal warning, you make a note, gave so-and-so verbal warning at this date. I think the question is, is it realistic for us to stand here and say, if you give someone a verbal warning on a job site, you got to make a note of it and put it in their file. Realistically, would that happen?
We all carry diaries, so we should basically just put it in your diary.
Oh, you carry a diary. So realistically, that should happen. You're warning them about something. There's
Right, Scott?
That's correct.
everybody. All right. But I think, there's no harm in over documenting what happens, right? And if, it could be a series of verbal warnings over a long time, and if you didn't document any of them, then you really have no evidence of that. And, sometimes it's not what happened, it's what you can prove happened. Drew.
I would agree.
He's the real litigator here, so I always run things by him.
Yeah, I would just keep it consistent. So if that's your practice, make sure it's your practice across the board.
Can you discriminate against somebody if they don't use their diary?
I think so, yeah. Go ahead.
Can you discriminate against someone if they don't use their diary? In our list of protected classes was a person with diary in there.
What if he has a bald head?
Follically challenged here.
I don't think that's not a unless unless you're undergoing chemo maybe.
The diary is part of EEO requirements. So they're required to complete their diary on a daily basis. So that would be
Right.
to write up.
Yeah, and I think that follows up on, that's a legitimate business concern and certainly grounds for taking action against someone who fails to do that.
Yeah. Someone not using their diary has really nothing to do with discrimination. It has to do with someone not doing their job. The question being, can you discriminate against someone for not using your diary? Sort of, no, it's not possible to discriminate against them for not using their diary because it's not a protected category. You're just enforcing, the rules of the company, if that makes sense.
Yeah, but now the flip side of that is if a lot of people, don't use their diary or don't enter notes into their diary, and you're really only following up on one specific employee because of that, they could come back and say, even though it's a legitimate policy and it's a requirement of the job, no one does it, and you're only picking on me for not doing it because I'm part of a protected class. So if a lot of people don't use their diaries, then you want to make sure, again, that you're consistent and following up on all of them.
Right. Other
Can you
questions?
tell these guys why it's really important to use the diaries?
Can we tell these guys why it's important to use the diaries?
What's that?
Otherwise, you'll fire them, right?
That happened.
Yeah, there you go. Pretty important.
So says the president. Otherwise, you will be fired. What we're talking about is documentation and how vital it is when proving something took place. If you're carrying around a diary, it really does, it makes a lot of sense. Write it down. You got it right there. Does that work? Any other? These are good hypotheticals. We got some more time on this presentation. So hypotheticals are good. Questions are good. Anybody else before you talk about disabilities? All right. So returning to your original question, so 7 questions ago, what if somebody can't lift a certain amount and that's a requirement of the job? Anybody have an idea what you should do if that's the case? Let's just say the job requirement is you must be able to lift 50 pounds. Person comes in and says, I can lift 40 pounds. I got hurt in the Iraq war, so I have a disability, I'm a veteran, but I can lift 40 pounds, can you accommodate me? Anybody?
What's OSHA standard?
What is it?
OSHA standard to lift.
What is the OSHA standard to lift? You might know. 80 pounds? So they must,
That has nothing to do with this.
well, let me,
The job requires 50 pounds, and I can only lift 40 pounds. you can basically not hire them because of that, I would think.
That's what I'm getting at.
You have to make a reasonable accommodation.
Yes.
So one person says you can not hire them. One person says you must make a.
I'm saying you can't, but I mean, if they can't lift the OSHA standard, which is the industry,
So OSHA standard is you have to be able to lift 80.
I believe it's 80.
All right, let me redo the hypothetical. Job requires you be able to lift 100 pounds. You can only lift 90 pounds. So we take OSHA standard out of the, right, we're just,
How can you make a guy lift over OSHA standard? I don't know, how
Yeah.
can you make a policy to tell you that?
I'm kind of stumped here.
It's 50 pounds.
OSHA's 50 pounds?
Stump a lot of people.
All right, I'm returning to the original hypothetical. Job says you gotta lift 50, guy comes in and says he can only lift 40 because he got shot defending this nation in the Iraq war. One person says you send him home. One person says make a reasonable accommodation. Anybody else want to wager an idea here?
We're using this as a pre-employment. The guy hasn't, he's interviewing for the job,
Correct.
and the requirement is 50 pounds, and he only can lift 40. Technically, you don't have to hire him, I don't think.
So you're saying, okay, you can't lift 50, you're out of here. That's,
No, but if there's 5 other guys that can lift 60 and 80 pounds, they'd be more qualified.
okay, okay. Just never call him back. All right. So this is sort of, when it comes to disability, this is a very sort of pivotal analysis, right? You got some other guys that can lift 60 to, sorry guys, can lift, 60 to 80 pounds, and this guy can only lift 40 and the job requirement's 50. My answer would be, and I'll let you follow up on this, it needs a deeper analysis. It would be very risky just to send him home right away, especially given, he's a veteran, he has a disability. The law mandates that you engage in the interactive process. We're going to talk about that, but you have to determine whether or not there can be an accommodation. So how often in this particular task do you have to lift 50 pounds? If it's 98% of the time, you really only have to lift 40 pounds. Is it unreasonable to say you've got the job and there's only 2% of the time that you have to lift more than 40 pounds? So it kind of depends on the requirements of the job. Anything you want to kind of add to that?
Well, I mean, typically when we see this, the reasonable accommodation and the interactive process, it is with someone who's already an employee. If they were meeting the qualifications of the job and then they suffer some sort of disability and they come in and say, I can no longer lift, 50 pounds or 100 pounds, then the employer does have a duty to see if there can be some sort of reasonable accommodation, which I think we'll go through a little bit more, but some sort of reasonable accommodation to accommodate that disability if they're already an employee.
I'd say if you don't hire him in that circumstance and you hire somebody else, it's good to have other reasons for why you didn't hire him, just from a, protecting the company standpoint. So you're right, you don't need to hire him, but if that person, there is a risk there, and what you'll want to do is, one of the main takeaways that we're trying to kind of instill in people here is just to pause, consider it. It may seem like, hey, I want to send this guy home, or I don't want to hire this guy, but we're in California and this is a very sort of difficult state, so it's worth just taking a second and say, well, let me talk to somebody. Let me, maybe we need to just run this by the attorneys just to make sure there's no exposure here. Even if it seems totally legitimate to just not hire the guy, that doesn't necessarily matter when it comes to whether or not there's going to be a claim filed against the company.
Yeah, but when you're interviewing people, you don't have to give anybody a reason why you didn't hire them. There's a whole list of people you're looking at interview-wise. The guy has this or that, it doesn't matter. You don't have to tell anybody anything. Why or how come you hired this person or didn't?
That's correct.
You don't have to justify it.
No, you don't have to justify it to him, but if it ever comes back to your doorstep, you'll want to have demonstrated that, you took this candidate seriously and, you know, went through the process and tried to see if you could accommodate him.
If he made it to the interview process and they did take him seriously, so I would think should be able to be eliminated.
Okay.
In the process.
If the actual interview is after a series of other, you know, tests and so forth, then that's probably correct.
What if they're just better hired? Like you've interviewed two guys, one guy's flat out better than the other guy.
Yeah, I mean, you can hire the potential employee that you think would be a better employee. There's nothing.
So maybe we always do it in bunches. You always hire two, so you can always say, well, this guy was better than that guy.
Yeah, okay.
It's about proving the case, right? I mean, that's all this is. It's all he said, she said.
Right.
Indeed.
Right. But, you know, I mean, the one thing you don't want to do is, you know, they come back and say, well, I didn't get hired. They thought he was a better or she was a better employee because I was a member.
You hired the other guy. Don't just say you hired him and then
Right.
they hired the other guy.
But yes, the big picture is you're entitled to hire whoever you think would be the best fit for the job as long as it's not.
It's basically, it's your interpretation of who you think is better. I mean, you're just making a judgment at that point.
Right.
And sometimes we make the wrong judgment, we hire the wrong people.
Right.
So if the requirement's 50, he says he can only lift 40, and you say, well, I'm gonna accommodate you, you hire him. A week later, he goes to lift something, and he figures out, you know what, I had my math wrong, I can only lift 25. Can you fire him?
Yes. So the question was, requirements, you can lift 50. Guy comes, says he can lift 40. You say, I can accommodate that. Hire him. A week later, he realizes it's actually only 25. Can you fire him then?
Yeah, I mean, for someone who lies during the interview process, that's a legitimate business reason to terminate somebody.
But he didn't lie, he just made an honest mistake, he said.
Well, I guess then we would get into the whole reasonable. Once they're already an employee, you get into the reasonable accommodation issue, which we have here on the slide. And for an existing employee, I think an easier example would be, let's say he could lift 50, he was on the job and he got hurt, now he can only lift 25 pounds. You as the employer do have a duty to see if there's some reasonable accommodation that you can provide that employee, and that can mean modifying their work requirements, modifying their schedule, giving them less things to lift, and there's no real hard and fast rule to determine exactly what the employer has to do, but it's I think a lot of people underestimate the duty on the employer to try to accommodate someone's disability, whether or not that's a physical disability or a mental disability. There really is a very high burden on the employer to engage in the employee, and we'll talk about this a little bit more, but to engage in the interactive process and really work out a way for that current employee to be able to continue on in the job. And in some situations, that can even mean giving them new responsibilities, giving them new tasks to perform. It comes down to really what the undue hardship to the company would be.
Can I add on?
Yeah.
Going back to your question, if essentially everything with this job is lifting at least 25 pounds, now he can't perform the essential functions of the job. So let's say, if he can lift 40, with an accommodation, he can essentially do the job. He can do almost all the jobs. Sometimes he needs a little help. That's reasonable. If it turns out he can only lift 25, you say, look, this guy, he can't do the job at all, right? So the analysis and the defense would be basically, well, with an accommodation, we thought he could perform the essential functions of the job. Turns out, he misinformed us, honest mistake, but now he can no longer perform those essential functions of the job. So, in our hypothetical world here, yeah, you would be justified in saying, look, there's nothing we can do for you. But going back to Andre's point, the law and the courts are on the side of the employees in this. And it's a high burden, and it's really, really important to demonstrate that we looked into we really tried our best to accommodate this employee.
So they're hypothetical then, because this is actually not necessarily uncommon. Because we have equipment operators, they don't have to lift much. We have laborers, they have to lift more. But for instance, I'm at a phase in point contract or with my project where we're making joints, so the person that I'm hiring, their job, primary job is gonna be lifting concrete sacks, that sort of stuff, helping mix mortar. The guy that I already have employed, his job may be to making them, which he doesn't have to lift as much. So if I'm calling the hall and hiring somebody for this specific task, and he comes and says he can only lift 35, 40 pounds, even though I have other laborers that don't necessarily need to do that, because I'm hiring for that specific task, can I say, hey, you know what, I'm sorry, this doesn't work?
And they're not an employee at that point, right? You're interviewing employees for a specific job, and if someone doesn't meet the qualifications for that job, I think you're okay not hiring someone that can't do the job.
If it's a union employee, you have to go through the union, Randy.
What's
Yeah,
that?
if it's a union employee, you have to go through the union, and there's certain rules for the union that are different with these.
Yeah, but
We have
here's
contracts.
the thing, Raj, is the union doesn't necessarily check any of these guys out. So I've had guys come out and say, oh yeah, my back's hurt and I can't do this, or I can't do that. We've had to deal with that before.
Well, I know there's stuff in the bylaw, in their bylaws for that say as a requirement, if they can't do it, then you can send them back to the hall.
In the first 2 hours, you can send them back, you don't have to pay them.
So some of,
Yeah, the folks can speak up during when you're asking questions, but I can kind of pick it up a little better. Be a little louder.
okay, great. That'd be helpful.
Still repeat it.
And just on the question of what is a protected disability. I think it's batteries. That's okay. On the question of what is a protected disability, I think it's a lot broader than a lot of people really expect. Again, like John said, that the law really is on the employer side and claiming certain disabilities. I mean, we see it a lot of times when people claim stress. You know, they go to the doctor and they get a note to be off work for 2 weeks because they're stressed out by the job. And you know, I'm sure your jobs are stressful. My job is stressful sometimes, but that can be a protected disability. It's all very fact specific, and it's hard to kind of give a clear answer of what is and is not a protected disability. But my advice to everyone here today would just be to assume if someone comes to you and claims they have some sort of disability or needs some sort of accommodation, that should definitely trigger some action on your part to look into that, to try to see if that's something that you need to accommodate, whether that's talking to HR or to a lawyer or to John or somebody. But most employers really do underestimate kind of the wide range of what protected disabilities are. And I did find a list, or there's only a few specific things that are not protected disabilities. On that list, you have things like a compulsive gambler, pyromaniac. That's about it, really. What's expressly not a protected disability. So
that's the list of non-protected disabilities.
Yeah.
All right, short list.
So just take every one of these things, if it comes across your desk, as something that should be taken seriously. I'm not saying it's 100% going to be a protected disability, but the range of issues that can be protected disabilities is a lot larger than people think.
And our job or a consultant's job is not to impede your ability to hire who you want and fire who you want. We want you to get the outcome that you're going for. Our position on this is also to protect the company and to take into account anything that maybe was overlooked during the process. Yes, sir.
Substance, like a substance addiction, part of disability.
It's a good one.
Disability.
It's a good one. We were just talking about this. Substance abuse, is it a disability? Do we have any slides on this? Or?
We don't.
Okay.
But I guess the short answer is if someone is trying to get treatment for a substance abuse issue or alcohol abuse issue, that is a protected action that may need to be accommodated. If they're showing up at work, high or drunk, that would not be a protected disability.
Right. The Americans with Disability Act and the ADA, we were just looking into this. It definitely says that alcoholism is considered a disability, right? So this is a good example of where the areas of the law really kind of conflict, right? You as an employer have every right to say you cannot be drunk at work. At the same time, the ADA actually recognizes alcoholism as a disability. So, and there's also a right to treatment leave if an employee comes to you and says, you know, I need to take a leave of absence to go to rehab. So that's definitely a tricky one. As soon as they show up to, you know, to work drunk, now they've, you know, then they can be fired right away. But it is considered a disability. So, you know, if I'm applying for a job and I say, well, look, I just want you to know I'm, you know, 6 months sober, I was a serious addict, you know, as long as I am the best candidate for the job and I stay sober, then that shouldn't be weighed against me in my, you know, in my application. It's a great question. It's good. I won't repeat that one. A note on undue hardship, right? Cost prohibitive. You know, I have, if the only way I can sit at my desk is I require you to buy me a $100,000 space chair that massages me while, you know, because of my injury or something, that's a cost prohibitive accommodation, right? Burden on operations, you know, going back to our lifting example, if somebody else has to lift everything that this person can't lift, now it's detracting from another aspect of the job. So these are, you know, factors that need to be looked at. And one of the difficulties about Andre's job, my job, is like every single situation is fact specific. It's not easy for us to say, oh yeah, you can always fire somebody in this situation, right? If you've seen circuit splits and case law and how complex the law is, you know, huge cases turn on really small facts. So just talk to, if there is a situation where you recognize, hey, you know, maybe, you know, this guy's not a pyromaniac or a compulsive gambler, so maybe this really is a disability. Let me, you know, bring it to Janet. Let's just run this by the attorneys. Better safe than sorry. And then hopefully they say, yeah, you know, go ahead, we're cleared to let this person go or not hire this person. But at least then you've done your part in protecting the company.
And I guess just one other note on reasonable accommodations is that it's an ongoing duty. We see cases like this, and there's a famous case of, I think it was a Safeway case where the plaintiff had to take frequent restroom breaks. And Safeway or her employer accommodated this for a whole year. There was no issues. They worked with her, really kind of made sure that this issue was taken care of. And then she got a new manager, or some sort of temp manager was filling in for one day, and denied her that one time to take some sort of restroom break. Thank you. Thank you.
Oh, yeah.
And so, you know, denied her after a year of really working with the employee, really kind of engaging in the interactive process, which we'll talk about. After a year of this, some new manager came in, wasn't aware of it, somehow denied her the bathroom break, and all of a sudden there was a lawsuit for, you know, serious, severe emotional distress. And the plaintiff's attorney was seeking a large amount of attorney's fees, and it was litigated all the way up through trial. And the court found that, yeah, even if you know, for a year have a perfect record of accommodating an employee and working with them, if you don't accommodate their disability on one occasion, that can give rise to a claim, and that can give rise to attorney's fees and all sorts of bad stuff.
And that's a good example. Sometimes you can't win, you know? Sometimes you do everything right and it still doesn't come out in your favor, but I mean, because this is California and it's tough, but you take the necessary precautions and you'll avoid that, hopefully, most cases. Yes, sir.
The difference between a compulsive gambler and an alcoholic.
I think it's the difference.
I understand the difference, right? I don't get it, but like to me, that's an external addiction.
I think it's a legitimate. Yeah. So, what is the difference between a compulsive gambler and an alcoholic in terms of the way that the law would view it? You know, I think it's. I don't know. Have they said that compulsive gambling is a disease? Has somebody come out and categorized it as that?
I mean, they have Gamblers Anonymous, right?
This is really this is a kind of discussion question that like would happen in a law school, class. But I think, for all intents and purposes, you're right. There's not a major distinction between one compulsive behavior and another. But I do think alcoholism specifically has been categorized as a disease. But this is me, making an argument as a lawyer. You got anything better than that?
Well, I mean, I think in this case, the only difference is that, there's a statute out there somewhere with a certain list that certain legislators put together, or certain case law that specifically finds something's a protected activity or not a protected activity, or a protected disability and not a protected disability. And there's a lot of times really not a lot of rhyme or reason to, what's on that list or not on that list. And a lot of these laws are not intuitive, and they're difficult to maneuver. Yeah. But a lot of times the law doesn't make 100% sense because it's written by legislatures, and that's why there's a lot of attorneys, I guess.
Yes, sir.
So is it possible that those two conditions present a serious risk of loss to the employer versus alcoholism, which maybe doesn't?
Yeah, makes sense.
The difference between the two being
gamblers and alcoholics.
And which one? Creating a serious...
Pyromaniacs, right? They're going to burn the place down or steal from the cash drawer to feed a gambling addiction, whereas an alcoholic is just going to be drunk.
Same time, if you're... Yeah. No, I think, pyromaniac is dangerous, as is potentially an alcoholic if they're behind the wheel of a semi-truck or something. But these are thought-provoking questions, and this is the kind of analysis that we have to do. Is all right, that's what this process is balancing the need for the need for the company versus the need for the employee. So we've already been talking about this, but the interactive process, it's sort of like a major legal buzzword. It's what has to happen every time you are dealing with someone with a disability. You, as folks in charge of hiring, firing, and accommodating disabilities, have to demonstrate that that you interacted with this person, you discussed it. I mean, it's totally based on reasonableness. A lot of AC over here. You guys, are we okay over here? Yeah. It's nice. Well, we got the bright lights on us. I kind of like. Anyway, where were we? I'm not distracted at all.
Yeah, I would just add that the interactive process, there's a lot of legal terms to it, but it boils down to a common sense duty on the employer to really go out of their, really try to engage with the employee to see if there can be something done to accommodate what they need to be accommodated. The duty, it could be triggered by an employee going to the employer and saying, I have this disability, I need accommodations, but it can also be triggered just by the employer somehow coming to know that the employee has a disability. It can be a third party that makes them aware of that, or even if someone's out on a lot of medical leave, that can trigger a duty on the part of the employer to inquire to the employee kind of what do they need any accommodation, and if so, work with them to accommodate it. And it's a two-way street, so the employee can't just sit back and not participate in it. But again, I think people underestimate how much of a duty this can be on the employer, that they really do need to try to work with the employee, get information from them, and really try to figure out a way to accommodate that disability. And it's a separate, it's a whole separate claim. I mean, we see it all the time where, you see 8 or 9 different causes of action and claim, and one of them is I had this disability, and you didn't even, ask me about it or try to work with me, and it's a whole separate part of a lawsuit that you have to deal with.
Yeah. Going back to my example of the Abercrombie headscarf thing, that applicant didn't tell the employer that it was for religious reasons, and the court in this case said she didn't need to. The employer should have recognized it and should have at least engaged in that conversation with her. So, it seems unfair, frankly, to somebody who might be an employer, say, look, this person, we've got this policy and the person didn't even tell me about it, and I'm supposed to be, figuring it out on my own. But I would say, and you tell me if you disagree, the burden for the interactive process falls more heavily on the employer. You have to prove that you took these steps and you reached out and you tried to talk to the employee in question. Would you say that's accurate?
Yeah, I mean, the law is that it's a two-way street, and they have the same duty to engage in the interactive process. But yes, a lot of times we see that it's more difficult for the employer to show that they did engage in the interactive process than for the employee just to say, I never heard from them. And this falls on the whole documentation and emails or whatnot, but you want to document the steps that you took to try to work with the employee. If you're calling them, if they're at home on medical leave and you're calling them trying to figure out what's going on and how can you accommodate them, that's something you might want to note down. But a lot of times it falls down to the employee's word against the employer's word, and it's hard to prove a negative sometimes, or hard to prove that you did something if there's no documentation about it.
Right. Another reason why, in these situations, rather than just not hiring the guy or letting him go or whatever, another reason why you should take a step back and talk to somebody is if the company has done a formal risk analysis with, say, an attorney like Andre's firm, that is a better defense. If somebody says, hey, you didn't hire me because of this disability, you say, well, we took all of the steps, we engaged in this process, we had a formal legal analysis done, a risk analysis, via the attorney-client privilege. So that's demonstrating that Mountain Cascade knows what they're doing, they took it seriously, they considered all of this, and based on the advice of their attorneys said, yeah, you can let this person go, et cetera. So, a lot of what we're talking about here is just preventative, right? It's as soon as you're on the receiving end of a complaint or a lawsuit, it's going to cost money. Even if ultimately you prevail, it's going to, take away from the job. It's going to take away from everybody that's involved in it. So really kind of trying to prevent this stuff is as beneficial to the company as, ultimately prevailing in the action. So we've pretty much been talking about this so far. When it comes to accommodating, what's important, what's not important, what are the barriers? Let's get creative. Let's figure out if we can accommodate this person. And as I said, breakdowns typically are attributed to the employer. This is more like recommendations. Document and writing requests. This is when somebody presents you with a request for reasonable accommodation. Somebody comes to you and says, hey, this is going on and I need an accommodation. What are the steps that we take? So one, obviously document. We've been beating that over the head. Figure out if the person has a disability. Chances are that they will, just based on everything we've been saying in California law. Ask them, this is pretty intuitive. What's the extent of the impairment? How disabled are you? What can you do? What can't you do? I think we do, in fact, have a break.
We need to take a break.
All right, I need, okay, take a break. We're doing the policy next anyway, so. All right, so one of the requirements of this training is that we review the policy. We've updated the policy. We've put some more language in there. We've kind of elucidated more examples and terms. So everybody kind of take a look at this, give it a once over. Essentially, your equal employment opportunity policy encapsulates everything that we've been talking about here today. So, I'm not going to sit here and read the whole thing to you, but familiarize yourselves with this policy. Keep in mind that the handbook is really where all the rules are there in the handbook, and we're working. I work with Janet every year to update it, and we release a new version of it. One aspect that is worth mentioning that I don't know if we've talked about too much is examples of reasonable accommodation, granting additional time off. So just be aware that is one way that accommodating, even if the person doesn't have any more PTO or vacation, courts have held that, part-time work, additional time off is considered an accommodation.
And I would just add, I think, yes, that this policy, it does cover a lot of the areas that we've talked about. One of the main takeaways I want everyone to take from this presentation is just that, what a recognized disability can be is very broad, and it's a lot broader than I think people expect. And there's a kind of understandable tendency if someone comes to you and claims they have some sort of disability, if it's not something obvious or like a broken leg or something like that. Sometimes people have their reaction to it is just to dismiss it. And I think unless, like we've talked, they're coming to you with some terrible pyromaniac or something like that, what you don't want to do is to just dismiss what they're telling you. You definitely want to discuss it with someone in HR or get a second set of eyes or ears on it to see if it is something that needs to be taken seriously, if it's a recognized disability. And if so, then definitely the duty is on the employer to really work hard with the employee to try to figure out a way to accommodate that disability.
Have we hit everybody over the head enough with that at this point to take it seriously? That's the goal of the training. All right, so this is the policy. Take a look at it, read it when you have a chance. The rest of the time talking about responding to complaints and retaliation. All right, so taking all complaints seriously, we've been talking about what is and isn't a disability, but even if something seems ridiculous at first, at least take it seriously initially, right? Take all complaints seriously. You don't want to laugh somebody out of the room and think that can't possibly be a real, recognized issue, and then later say, oh, I did not realize that it is. Be familiar with company policies. We're doing that. I like this one. I kind of gave it away here, but complaints, are they confidential?
Wait, complaints against another employee or complaints about?
Yeah, if an employee comes to you, well, let's say, because I don't want to eat into my anti-harassment material here, but let's say, somebody complains about needing an accommodation and says, I don't want, don't make a big deal out of it. I just, I needed this and it didn't, so-and-so, my manager didn't accommodate me. Just keep this confidential. I don't want to anybody to know. Can you promise, yeah, okay, I'm not going to tell anybody about it? I think you had the right answer if I heard you correctly.
The complaints have to be investigated, so that by nature they can't be confidential.
That is it. You have to investigate this. We'll talk about this more in the next 2 hours. But yeah, you can't promise to keep things confidential. Assure the employee there will be no retaliation. We're going to talk about this a lot. It's very, very important that people know that there's an open door, that people know that they can have this conversation, that they can talk about the need for an accommodation. If somebody did have, say, an alcohol issue, they would probably be very afraid to come to the manager and say, look, I need a week off to go to this, or probably you need more than a week off, but reassuring somebody that comes to you asking for an accommodation, reassuring them that they're not going to be retaliated against is important. If somebody comes to you, it's probably a good idea to tell somebody else, HR, whether it's Janet, whether it's somebody. One of the ways that companies get in trouble is somebody makes a decision, without consulting anybody else. Maybe they make the wrong decision, and maybe it could have been avoided by just talking with somebody else within the company. Anything to add on?
Well, you might touch more on this, but in terms of the investigations, definitely something to keep in mind if you're involved in an investigation into the complaint is, again, kind of more of the same. Is you want to make sure that it's neutral. If someone comes to you with a complaint and you launch into an investigation, you want to make sure that you're not launching into it to try to prove or disprove somebody, and that sometimes can be difficult if it's a complaint against a coworker or somebody that you've worked with for a number of years. That may be difficult, but you want to keep it a kind of fact-finding investigation. That's the purpose of an investigation. It's not to really, disprove somebody's claims or prove one side over another. You certainly want to document a neutral investigation into somebody's claims.
So already just talked about retaliation, but what is retaliation? Well, retaliation is taking an action against somebody when they've come to you. But other examples of what you can't retaliate against, whistleblower claims. If somebody comes and is reporting illegal conduct, obviously that's a protected person. You can't demote them or take any adverse action against them. Same thing goes for somebody filing a discrimination claim or filing a harassment claim. This can get difficult when somebody is filing a claim against the company, but they're still working there every day. There can be the perception that this person's not on our side anymore. They're actively working against us, but acting in a manner, treating that person differently is only going to exacerbate the situation. So it's very important to make that effort to be sure that you don't retaliate or treat that person differently despite having filed a complaint.
Yeah, we do a lot of these retaliation claims, and it can be, the reports of illegal conduct. It can be the employee reporting it to a supervisor at work if they believe that it's some sort of illegal conduct. I'm not sure what that would be, but it can also be to government agencies. Those would all be protected activities that you can't retaliate against. And we see a lot of these types of claims. And then just kind of going back, though, to the retaliation one, complaints at work, of course, are pretty common, and not all complaints at work are protected activities. If someone's complaining to you that they don't like, someone's management style, or they don't like a coworker, or they don't like a certain way that, the job is being run, that's not necessarily a protected activity. It has to rise to the level of legal conduct, or at least they think it's illegal conduct. So that's the kind of stuff you want to look out for. Yeah,
this chart and statistics surprised me, actually. Retaliation is the most frequent EEOC complaint charge. I think part of that is because people get laid off, and everybody that gets fired feels like they've been terminated wrongfully to some extent. It seems you're already angry and hurt that you've been terminated, but obviously this is happening. It's happening on a major scale. So being really cognizant and just being aware of how, if somebody is coming to you, how you treat that person after the fact. Obviously, there's thousands and thousands of retaliation complaints being filed every year. A little more on retaliation. Can't discipline, demote, terminate. We've kind of covered this. Complaining employee must have a good faith, reasonable belief that the conduct is unlawful. Obviously, you can discipline somebody who is just being a pain, right? If somebody comes to you and is complaining about, something that is not in fact unlawful, then it's not retaliation, right? So unless they have a good faith belief, then you can obviously discipline that person. So we've covered most of this. A note on supervisors, just real quick. One reason we have this is there's much more liability attributed to the action of supervisors. Supervisors can be charged in their individual capacity because they are supervisors, but two, as agents of the company, something that you do is immediately going to be attributable to Mountain Cascade because you are a supervisor. So you'll see a lot of these trainings, the requirement is for managers and supervisors, it's because the liability is so great, and if somebody's going to sue, they want to sue Mountain Cascade because that's where the money is. Here's some examples of retaliation. Unwanted, undeserved performance reviews, transfers, duty changes, denying of privileges, ridicule, blaming a person for work problems. So, there's an endless amount of examples of treating somebody worse because they've filed a claim. So, the main takeaway here is don't do it, right?
Well, and I would also just add that this, again, touches back on what we talked about earlier, is that you want to keep things consistent. So, for example, if you've been documenting an employee up who's performing not very well for a year's period of time, and then all of a sudden they make some sort of claim to their supervisor of illegal conduct or to a government employee, and you continue to document them, you continue to document their issues, that could be okay. If you were doing it before and you kept doing it after, that actually might be evidence that we'd look at to show that their complaint didn't really change the way you were dealing with their behavior. If it's a different situation where there's no write-ups leading up to the time the employee makes this complaint, and all of a sudden they start getting write-up after write-up for things they were doing before the complaint, I mean, that can be evidence of a pretext then, and they could point to that and say, this was not a problem until after I made the complaint. So again, just the takeaway is to keep things consistent and keep it neutral with all the employees. So if you're writing everyone up, that's fine. You can continue to write up an employee who's made a complaint, but just be cognizant of changing your behavior towards an employee after they've made some sort of complaint.
Any questions about everything we've covered? We're at the end here. Yes, sir.
Stupid question. Our policy lists political affiliation as a protected class. Is that now a protected class? Because I remember last time we were meetings it was not.
I don't know that it should list that. Where does it say that? Let's see.
Second paragraph, 1, 2, 3, 4, 5, 6 lines up from the bottom. Taking or requesting statutorily protected leave, political activity or affiliation or any other characteristics protected under applicable city, state, and so on.
Okay. Prohibits discrimination, political activity. It's not a protected class. Have you seen that before?
I have not seen that before, but I would think that it might give rise to certain, constitutional rights to associate and to participate in whatever political activity you want to participate in.
That's what it is.
You have the right to do so, but you don't have the right or freedom from consequence of doing so.
In the case of voting.
In voting, yes. Yeah, if you got to vote, you have to, you can't hold that against you.
So you're talking about political affiliation?
Yeah, if I'm registered as a member of the Peace and Freedom Party and decide we don't like the Peace and Freedom Party, that's not protected.
Yeah, you can't, as an employer, limit people's ability to associate. I think there is I think I know what this is kind of implicating, but just as a basic answer, political affiliation is not a protected category. I think this has to do more with I think it's a federal statute implication, but it's kind of obscure. So to answer your question, political affiliation is not a protected category. So we might have to review that one. Yes, sir.
Are you seeing any new laws being developed, or case laws for social media? With the new generation coming, everything is social media platforms. And with the whole freedom of speech and social media, is there anything out there that, if somebody says, something bad about your company, but it's their off hours on their social media platform, is there a reason there for termination or to be written up?
It's a great question.
I don't know if there's any new law specifically protecting, someone's right to engage in social media. I mean, if someone is posting things on Facebook that are negative about the company, I don't think it, violates freedom of speech to take issue with that and to have some sort of adverse employment action with that person for that. But social media, the way we deal with it a lot is it definitely comes into play in a lot of employment cases because, again, it's one other way that people either intentionally or unintentionally document things that are going on with their employment. And sometimes you see, plaintiffs, for example, they claim that I was a great employee and I love my job, but you go back and look at their Facebook profile, which a lot of times is public, and you can see them, like you said, posting negative things about their employment and negative things about their employer. So that's kind of how it comes into play with what we do. But I have not seen any new laws really protecting someone's right to go on social media, no.
There are, I mean, this stuff is starting to be litigated, obviously, but the law is always reactive, right? It can't really foresee certain things that are happening. The social change happens, and then the cases in the court law come after. Like self-driving cars, there's going to be just waves of litigation in terms of who's liable and what the laws are. There definitely is. Social media has become a new medium through which people can harass each other, through which discrimination can take place. So from that perspective, yeah, I mean, whether it's text messages, whether it's Facebook posts, whether it's, things people share, it's a whole new world of opportunity for, like you said, somebody disparaging the company, on their Facebook page. And can they do that? Is that protected speech? No, it's not from a perspective of an employer. You can let somebody go for doing something like that. But yeah, it's definitely, it's kind of a fascinating issue because suddenly what used to be private is out there for everybody to see. So what used to be kind of a grumbling backroom conversation, people are now having on Facebook or Instagram, something like that. So the law is changing and these things are kind of becoming incorporated into it. Any other questions? All right.
Well, then I'll just add just a few kind of takeaways from this 2-hour presentation here. But the specifics of everything, like we talked about, are very detailed and hard to kind of give you guys hard and fast rules for discrimination, protected classes, who you can fire, who you cannot fire. I think the takeaway from today is really to just raise everyone's awareness that these are the broad categories of things that you as supervisors or managers or people who are dealing with other employees need to be aware of. And certainly if something comes across your desk or to your attention, it's always a good idea to bring it to HR or to get someone else's opinion on it if that's something that you need to take care of or look out for, accommodate. The documentation that we talked about, it really is a lot of times our best evidence that we look to prove things that are hard to prove. To prove what was someone's, what was in their mind when they terminated somebody. Was it a discriminatory reason, or was it really just focused on that person's job performance? So the documentation is important. The emails, again, is something that 2 or 3 or 5 years later, a lot of times we see this emails come up and people forget about them. And it's understandable. People are emailing with coworkers back and forth that they've been working together for 10 or 20 years, and sometimes a simple joke can look very differently projected in a courtroom than it was meant to look. And just I think the overall theme is really try to be neutral in the way that you deal with people. So if you have a practice of writing up somebody for one type of, whatever it is, one type of performance issue, just be mindful of the fact that, you should probably be doing that across the board with all the employees.
Agreed. Thanks, everybody.